পালং শাক কেনার মতো অর্ডার পাওয়া যায় এখানে। Go and file a criminal division here. No course steps shall be taken. After 15 days, matter will come. After 2 weeks, 3 weeks, then on the 3 weeks you will go. Why? Why you are opposing?
This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Well, whether this discloses an offense, this discloses an offense. Which section will apply, which section will not apply? This is not the stage to argue. At the framing of the charge, whether this section will apply, no, this section, not this section. Whether High Court will go into these niceties. Then nobody is required to go to the criminal court as usual. At every time it will come. Framing of the charges, it should be scratched from the statute itself. But people will come here and say, no, my lord, decide it. This is the chapter. This section is not applying. This section is applying. Whether by using certain expression or by saying so, whether this writ court can be turned into a trial court. To enter into the question whether this section applies or this section doesn't apply, whether cognizable case has been made out or non-cognizable case has been, whether bailable offence has been made out or non-bailable offence. Is it the task of the writ court what my learned friend has invited to your lordships to go into the process? Our days, we have never thought about to come up in the writ court for quashing on FIR, except in very, very few cases. And with great respect to your lordships, my lord, kindly do not take me amiss if I say so. This High Court has indulged for several years to entertain these types of writ petition. That is the reason, my lord, this is the cases are piling up here. With great respect. Come here, go take an order, no course step, finished. I'm not talking about this court, I'm talking about persistently for 5 or 6 years is going on in this cycle. Indulgence of this High Court is too much, to that extent that each and every case one will come and take an order and go. Why this Court Rumor 28? I have been heard that the Justice Oka has said that there should be a single magistrate. Why? Better you give this to the 226 court is there. Nothing is required. No application of mine on the very first day. First order is no court system should be taken. Is it appropriate for the writ court to pass an order mechanically in this way? In number of petition number. I am not saying, my lord, kindly do not take me amiss. Today, let me express myself to your lordships, my lord. What the pain being a senior lawyer I am having here in Calcutta High Court. I was also a junior, I have started my practice. To a certain extent, I know about the constitutional law. I was dared to come. Senior used to say, ja, laki diye petabe. On each and every matters, each and every matters. Now see, my lord, this is the FIR, this is a disposal offense. What more you will lordship needs it? Very simple. Very simple. And once an interim order is, my lord is hearing, I am lucky that I am being heard by your lords. I am lucky. Being a state, I am lucky. Painful incident is this. If a political person moves here in High Court, gets an order, you go to Supreme Court, up to Supreme Court will, no, my lord, we will hear the matter within certain days. Despite the order has been passed, High Court could not pass it. Hear the matter. Hearing was concluded by me in December 2023. Today, up till the judgment has not been delivered. where I am living. One of the demands of mine in this Calcutta High Court is this. Only the powerful persons, the political persons, whenever it comes and gets an order, this order is not available to a general litigant.
Mr. Bandhavadh, this is not correct. I believe I do disagree with you, sir.
That's it. Last 5 or 6 years I am looking into this.
Maybe in few cases there were cases. You also understand, Mr. Bandhavadh, all cases at this stage being a senior counsel, you know there are cases where there are multiplicities. I don't say that in all cases. There are cases, obviously.
No, that's all right. My lord, what is troubling us? There is multiplying cases, of course. With a simple these types of FIR and etc. I am not talking about a single one. If you give me scope, I will give you 50 references. The point remains, my lord. Kindly excuse me for saying, it is a duty of the High Court is first to see whether FIR discloses an offence or not. Do not kindly, the High Court should not pass a mechanical order, no cognizable, no coercive steps should be taken, or no investigation should be there mechanically. Then one has to come to such a finding. No, there is no offense. It is not disclosed any offense. Therefore, I am passing an interim order. I don't find any single cases. My lord, I am sorry that your lordship is not agreeing with you. Maybe. But unfortunately, my lord, I am also not agreeing with all of your lordship's view. We are also in a receiving end. Sometimes time comes when patience is broken. Time comes. And that time possibly has come today. What I am saying, nothing meaning for particular code or particular lordship. What I am saying about this institution itself. What is happening? One after another matter. And if I go to a judge and say that you have passed this order ex parte, you have said that this after 10-day matter will be heard 15 days. Judge becomes annoyed. You are dictating me to hear the matter. Where I have gone? Is it my institution? Anyway, my lord, do not mind.
No, sir.
I am just simple. I don't know whether the moment you have elevated as a judge, you are within a very
short campus, sir.
Short campus.
I don't disagree with that.
Therefore, so many things are not known. So many things are going on, especially in the criminal jurisdiction in Calcutta High Court. Very unfortunate, very unfortunate. Judge becomes annoyed. Why are you saying to oppose? Why you are opposing? I am taking up the matter. I will hear the matter. Interim order is extended. I will hear the matter in the month of March. March will come. Extreme order is extended. Hear the matter in the month of June. I can't oppose. Judge will come, judge will go. 5 years, 8 years, 10 years. Institution will remain, lawyer will remain for 50 years. Unpolluted institution can be made a polluted institution by a single judge even. Now, this is the FIR has been drawn under
criminal jurisdiction was all right, sir. You have grievance regarding the criminal jurisdiction or the criminal jurisdiction?
Read criminal jurisdiction. Palong shak kenar moto order pawa jay ekhane. Go and file a criminal division here. No course steps shall be taken. After 15 days, matter will come after 2 weeks, 3 weeks. Then on the 3 weeks you will go. Why? Why you are opposing? happening. And I am not worried. I will speak on the one day in the floor of the parliament what the Calcutta High Court, one or two judges will do. I have to say it to the nation. Nation must know. Anyway, my lord, your lordship will decide your matter on merit. It's not that. Not take it another way. Is one of the things that I have got your lordship. I have opened up. Do not take anything personally.
No, I have never.
But I am more thoughtful than any other poor person. So for this whenever I go, either in the floor of parliament or whether in the Supreme Court, if I speak something for this is your High Court. I have to hear that. If I simply have in a practicing lawyer coming to court, from house to court and court to house, and with in a Friday in a good party, then I would not have bothered you. Remember, this is the sections has been given 126 so and so, so and so. Now, kindly see what notice they wanted to give it. The notice under section 190, 160, 169. Because of another case was initiated earlier. 179 BNF. What is the order about that? Kindly come to 12 February 2024 order 140.
But would you want to do it before the other bench?
No. Before you, not before you. No. It is not. Nothing has to be said to against you. You never mind it. Rather.
No. Another bench has passed an order.
No. I want to do it before you. If it is another bench, it matter will not be never be heard. That's the reason I said I am lucky that the matter has come to you. That this matter will be finished. But I am tired of. Why I am saying I am tired of. Last 4 or 5 years, every day, went on, argued a matter for 15 days to 20 days, hearing the petitioner for 60 days. This council's judgment has not been delivered. You dismiss you allow his petition. I do not mind. I do not mind. But please do something. I am tired. I have said to the court also, I am tired of. No, when he used to come in 1981, came to the court, Begin was there. It's two big institutions where I was everyday learning, everyday energy, every day. From the judges got the spirit, from the seniors got the spirit. Even 4 or 5 years before, when I used to come to the High Court, there are so many things to learn. Today I feel that this institution has been failed to discharge the duties. This institution. I'm not particularly saying it. But I think frustration of almost 90% lawyers are there. Ki hobe dada? Piling of matters, clients are coming. Fortunately, I have got this senior gown in 2003. Otherwise, I did not have the direct contact with them. Otherwise, I would have been admitted into a mental hospital. So many persons blame the lawyers, juniors, etc. Judges says why judges are annoyed when they are mentioning. Have anyone has felt the pain of the lawyers? 5 years, 6 years, 8 years. What is the writ petition about? Criminal division. What is going on? This is nothing to you, but I am saying when I was getting a chance to tell. Will not kindly see the order.
Order.
At this page 140. This is an order passed in earlier reports. That is their criminal division, this petition. No, I am so disturbed. I couldn't sleep for 2 nights when a judge has said to me, you are dictating. When I am saying, kindly hear me. I am so shocked. Interim order was ex parte. The day I went there, this is the lawyers for other side. Please hear me. You have passed an ex parte. Hear me. No. When I was insisting, hear me. You are dictating me. You are having a bad behavior. I have to hear this. After putting 44 years practice from a criminal bench. I will not forget that day the judge has said this. I will not forget. And I will make her understand what you have said. Can you read page 114? The petitioner seeks quashing of FIR in connection with Bhatpara police station case number so and so. But last part, the learned counsel submits that the petitioner entered into a development agreement with Arjun Singh, then chairman of the Bhatpara municipality on 8 Jan for construction of a residential and commercial complex under the PPM model. The project was completed and complete certificate issued so and so certificate of the state person in the present. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party. Let the matter appears under the heading contested application. Investigation of this case shall continue. No coercive steps can be taken against the petitioner in connection with the present petition till 28 February or until further, whichever is earlier subject to suits. Now, here, investigation has directed to continue. No coercive steps shall be taken. So for the purpose of conducting investigation, I have to start the notice. And that was a purpose in the FIR. The notice which I wanted to serve for conducting the investigation. Kindly come.
Just one thing you satisfy me.
Yes.
In your opposition, you have taken the point that there was a change of the investigating officer. Where is that in the case diary, sir?
Page number 1.
That was on which date? Don't have to give me. I want the date actually.
2nd December 2020.
2nd December. And 2nd December 2000. And this person went
21st December 2020.
for serving the notice.
This is the first.
Yes, Mr. Wanda.
What I have taken in my affidavit in opposition, Lordship has read it, I think so.
I will glance through it.
Yes, therefore your Lordship asked me the question. If it is required, I will again point out, but the point I have to answer, I was reading with it. I have said I have nothing to do, more arguments I am not required to do. He has made so many arguments, so many facts, so many things. I am not going and falling into trap.
I think you don't argue anymore. I don't think you have anything to argue.
This was few.
Yes.
I can give 1 minute. I just the case laws minute. Just one is this first of all. Joseph down by encyclopedia. Your Lordship will get it, or I can hand it over. FIR is not encyclopedia. When the investigation by the police is in progress, the court should not go into the merits of the allegation in the FIR. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy facts that the complaint FIR does not deserve to be investigated. That is my lord Niharika. Niharika's judgment 2020. My lord, can I, if your lordships do not mind,
Yes.
do not mind, can I just hand up my lord my note?
Yes,
This-
yes, yes, yes. Only one point I will ask you to
Yeah.
argue. This is, I wouldn't have. But since you have enclosed and opened up everything in the affidavit in opposition, one point I believe should be a part, since I've got to deliver a judgment on the issue, that evidentiary value of an injured witness.
No, my lord, this is not the stage at all. They have done it. This is not this. My lord, I think this is not the
This
stage.
is not the stage, but
Not-
these documents have been unnecessarily enclosed in the
It is
affidavit.
not the stage they have done it. My lord, by mistake, it has been done. This has not been done. Very junior has done it. This evidently, my lord, I said I submitted to test the FIR.
That was enough, actually.
That's enough. For that, no evidence is required. Whether it discloses offense and offense or not. And so, for the malafide, my lord, I have to say.
Yes. Malafide.
Yes, kindly just hear this.
Ah.
Two principles. Because it is often it comes in two principles, two judgment I will show to your lords. One of the judgments of justice delivered by Justice Manoj Mukherjee in Supreme Court. That I will show fast. কোথায় গেল তো জুনিয়রটা কোথায় গেল দাদুর জাজমেন্টটা পড়েছে না না পড়ে মেলাপিটে করে বলছে
You prepare everything, 18th I will complete the matter.
The interim order was till 13th, that may be extended. 13th of March.
Oh. The interim order earlier granted is extended till 31st of March 2025. Mr. Bandyopadhyay, the senior advocate appearing for the state, has concluded his argument. Mr. Mojumdar V.L. Will give his reply and the written notes of argument, if any, on 18th of March
Shall
2020.
give reply along with the written notes of argument.
May